I'm going to go ahead and get us started. My name is Hannah. I'm a practice area consultant in the Washington area. And I'm really excited to have Adriana Quintero with us today. She is a member on my team who now works with law firms in the California area, but she used to be a former deputy public defender. So I'm really excited for her and her experiences with you today. She's going to go over some of her experiences and backgrounds in criminal work, and then some tools and resources on Lexis. I will be monitoring the chat as we go through today. So if you have any questions for her, please feel free to pop them in the chat or in the Q&A. And then at the end, we will be able to go over some of those questions. Otherwise, I'm going to go ahead and hand it over to Adriana. Once again, thank you all for joining us, and thanks, Adriana.
Hi, Hannah. Thank you so much for that introduction. Hi, everyone. I'm Adriana. I'm so excited to be here with you today. I am a Lexis consultant, and in my current role, I work with legal professionals at large law firms, and I assist them with research assignments and learning how to navigate Lexis tools and resources. And Hannah's correct. Before I joined Lexis a couple of years ago, I was a criminal defense attorney for 7 years. And I started out my practice as a deputy public defender in Los Angeles County. And then I had my own private criminal defense firm. And I am licensed in California. So our agenda for today is we're going to do a quick criminal law overview, followed by going live on Lexis Plus. I'm going to show you the key locations to find some of the top criminal law resources on Lexis Plus. And then finally, we're going to go over some best practices for tackling 2 of the most common assignments that you'll receive if you're working in the area of criminal law. So the first thing I wanted to just go over very briefly is the life of a criminal case. Because my experience is in California, that's what I will be speaking to today. So in general, you'll see on the screen here that this is the typical life of a criminal case. An incident occurs, the police make an arrest, then the police will investigate and prepare a police report and gather any evidence, so photos, audio, that kind of stuff. That report and any evidence gathered is then forwarded on to the prosecutor, and the prosecutor will review the police report and any other evidence and decide whether to file charges, and if so, what charges are supported by the evidence. Once the case is filed, the accused person is notified, and you have the first court hearing, which is right here. It's called the arraignment. At that hearing, the accused is advised of the charges against him or her and then provided with discovery. So that's the complaint with the charges and the police report and maybe photos or videos or witness statements. Usually at the arraignment phase, the accused person will enter a not guilty plea. If it's a misdemeanor case, the next thing that would happen is there would be probably a few pre-trial hearings where you go to court, the defense attorney and the prosecutor meet. The defense attorney might request additional discovery or evidence from the prosecutor. Sometimes the parties will litigate motions, like motions to suppress evidence, motions to dismiss. And the parties will also engage in negotiations in order to try to resolve the case or settle the case. At the end, though, it's up to the accused person to decide if they would like to go to trial or settle the case. If it's a felony case, it's a little bit of a different process. After the arraignment where the person pleads not guilty, then the case moves on to a preliminary hearing. And we're going to be going over how to prepare for a preliminary hearing a little bit later, because that is a very common assignment that you will receive if you work in criminal law. So the purpose of the preliminary hearing is for the judge to decide whether there's enough evidence to hold the accused person to answer for the charges. If so, the case will move forward. And the prosecutor will have to file an information, which is the second complaint. The person will be arraigned again, and then it moves forward through the same process as a misdemeanor case, which is a series of pretrial hearings, and then either resolve the case or go to trial. If a case goes to trial and the person is convicted, the final hearing would be the sentencing hearing. Okay, so you've heard me mention a few times misdemeanors and felonies, and so just wanted to quickly go over that. A misdemeanor is a lesser offense than a felony, and the maximum sentence you can receive in California is 1 year in jail for a misdemeanor, whereas felonies carry a maximum sentence of life in prison. So I've also mentioned prosecutors and defense attorneys a couple of times now, and so I just want to make sure that we are on the same page. In the criminal law world, these are the two types of practitioners, prosecutors and defense attorneys. There are two types of defense attorneys, there are public and private. Public defenders are the state appointed attorneys. Everyone's entitled to have an attorney represent them, and if they cannot afford one, then they are given a public defender, and private defense attorneys are the ones that people hire to represent them. You might be wondering what it's like to practice in criminal law and some of the day-to-day responsibilities for defense attorneys and prosecutors. While every day is a little different, the main responsibilities for both defense attorneys and prosecutors involve court appearances, which are very regular, if not every single day, close to every single day, litigating motions. So that means filing a motion to suppress, opposing a motion to suppress, putting on live witnesses, that sort of thing. Negotiating with opposing counsel to try to perhaps resolve the case or get a charge dismissed, that kind of thing, and jury trials. Now, in terms of responsibilities that are specific to defense attorneys, those include reviewing the discovery, interviewing your clients, preparing a defense, investigating the cases, and interviewing witnesses in order to prepare the defense. On the prosecutor side, some of the responsibilities that are specific to prosecutors include reviewing police reports and deciding, whether to file charges, filing charges, and then interviewing the alleged victims or witnesses. So that's it. Now we're going to go live on Lexis. And okay, so here we are at the Lexis Plus homepage. And there, I'm going to show you the place that I go when I'm looking for practice area specific resources, and that is down here in the Explore Content pod. So you can browse our resources by content type and jurisdiction, but today I'm going to show you how you can get to the practice area pages here. So I clicked on practice area, and I'm going to scroll down here to criminal law and procedure and click right here. So the resources that you see here are all of our criminal law and procedure resources, and everything's located in one centralized location. These are not jurisdiction specific, so they're all of our resources. And as I scroll down, I'm going to call out a couple of the sections that I think I found to be most helpful when I was practicing in criminal law. And that's the case-related materials, specifically the jury instructions. We're going to talk a little bit about this, more about this in a couple minutes here. But this is one way that you can access jury instructions. And then the second section is the secondary materials. So a lot of times you might encounter an issue, or you're working on the Fourth Amendment and you just want to get a sort of general understanding of that particular topic. It might be a more nuanced one, and you just want to kind of understand the lay of the land, and secondary materials are a great place to do that. Secondary materials explain the law to you, and they also provide to you any seminal cases, codes, statutes that you should be aware of, and it'll be hyperlinked. So that's a really good way to get up to speed. Okay, so now I'm going to go back to the Lexis Plus homepage, and now we're going to move on to the next portion of our presentation, and that is we're going to walk through a couple of the most common assignments that criminal law practitioners receive, and we're going to walk through how you can tackle them. So one of the most common assignments is preparing for and conducting a preliminary hearing. As I mentioned before, the preliminary hearing is specific to felony cases. And this is the hearing where the prosecutor will present live witnesses and evidence. And the judge is going to decide, after hearing the evidence and allowing the defense attorney to cross-examine, and the judge is going to decide if there's enough evidence to continue prosecuting the person for the charges that they are currently facing. The prosecutor has the burden to show that there's probable cause that the accused committed the offense. At the conclusion of the preliminary hearing, the judge decides whether to dismiss the case or whether the case can proceed. So it's a really important hearing. And there is no jury. This is totally decided by just the judge. So whether you're a prosecutor or defense attorney, one of the key things that you need to do at the very outset of preparing for a preliminary hearing is understand the charges and know all of the elements of each of those charges. So the best place to get that information is to start with the criminal jury instructions. So I'm going to start typing in here, California criminal jury. And as I'm typing, you'll notice that the word wheel is giving me suggestions down here. And actually, this is what I was looking for. The Judicial Council of California Criminal Jury Instructions, also known as the CalCrims. So I'm just going to click right there. And we're going to go to this list of jury instructions. So there are a couple different ways that you can do this. You can search for the particular charge, or you can scroll and do some browsing. Browsing takes a little bit longer, but you can definitely do that. So let's say we're working on a case that involves criminal threats. That's one of the charges. So we can expand this and we can look for the jury instructions this way. And there it is. But another way that you can do this is just by simply typing in criminal threat. And I always like to make sure that I have this little box checked here. So I search all the documents in the source. Otherwise, I'm only going to be looking through the table of contents. So I'm going to hit the search button here. And then I'm going to sort by content. And here we go. Here's our jury instruction. I'm going to click on it, criminal threat, Penal Code 422. So you'll notice here that you have these different numbers. These are each of the elements that a prosecutor is going to have to prove for a person to be found guilty of criminal threats. And it tells you to prove the defendant is guilty, the people must prove that the defendant willfully threatened to unlawfully kill, et cetera, et cetera. So there may be some terms that are used in here that require some further explanation, and you'll find that listed just below the element. So it explains what the term willfully means in this context, great bodily injury, that kind of stuff. So we're going to continue to scroll because jury instructions have so much good information. As we scroll down, we're going to get to the bench notes, and these bench notes are guidance for judges and something you should definitely read and be familiar with, because there could be something in there that's helpful for you as you're preparing your case. We're going to continue to scroll down. Now we have authority. This part is super important. Sometimes after reviewing the information above this section, maybe you're still unclear about what exactly constitutes great bodily injury. So you can go to that penal code section, hyperlink there. Sometimes you want to know, what about the sufficiency of the threat? You have some cases listed here. Lots of good information for you to really prepare for the particular preliminary hearing. I'm going to keep scrolling. Other good information here. Lesser included offenses. So sometimes maybe in this preliminary hearing, maybe the judge finds that there's not enough evidence for the person to be bound over for criminal threats, but maybe there's enough for an attempted criminal threat. So that's an information that you need to be aware of, no matter which side you are on, prosecution or defense. Related issues. This is kind of interesting. Ambiguous and equivocal poem insufficient to establish criminal threat. So lots of good information, hyperlinks to secondary sources to explain a little bit more about this particular charge. So it's definitely worth fully exploring the jury instructions. Another way that you could approach preparing for a preliminary hearing is by simply pulling the statute. So the statute for criminal threats is California Penal Code 422. So I'm going to type that in. And hit the search button. And here you can read the language of the statute, though it's often not quite as clear as looking through the elements. There is some really great information, specifically in the notes to decisions. So I'm going to click over here to just hop down to that section. So the notes to decisions will give you explanations on some of the different issues that are listed here. Like, let's say that, stick with the idea of the attempt. Let's say that we're working on a case that maybe the person's charged with an attempted criminal threat. So here you get more information on other cases that have dealt with the issue of an attempted criminal threat. It's good to read through these different sections and maybe link out to these cases and read them if that could be helpful for you as you prepare your case. Finally, I'm going to click on research references down here because this is also a really great place to come to pull. You can look at law review articles, treatises, and jury instructions. So you could always just pull the statute and then get to the jury instructions this way as well too. Okay, so those are the two ways that I would approach preparing for a preliminary hearing. Get familiar with the elements and what the charge consists of and go from there. Now we're going to move on to another very common assignment, and that is preparing for a motion to suppress. A motion to suppress is basically asking the court to suppress evidence because it was obtained in violation of the Fourth Amendment. So as you can imagine, defense attorneys file a lot of these motions. So of course, that means that prosecutors oppose a lot of these motions. And both sides have to do thorough research in order to be prepared for these motions to suppress because they are very fact specific. So motions to suppress occur in a misdemeanor case, usually right before trial. In a felony case, they typically occur at the same time as a preliminary hearing. So in felony cases, the defense attorney, usually if there's a motion to suppress issue, they would file the motion to suppress just before the preliminary hearing for it to be heard at the same time. So again, a motion to suppress is the defense asking the court to exclude evidence that was obtained by illegal search and seizure in violation of a person's Fourth Amendment right to be free from unreasonable searches and seizures. In California, you might hear these motions referred to as 1538.5 motions because Penal Code Section 1538.5 is a statute that provides for suppression of evidence in these situations. So let's say that we have a case that we're working on and these are the facts. An officer pulls a driver over for a broken taillight, and during the stop, the officer smells the odor of marijuana. The officer then searches the entire vehicle and finds a gun. So the issue is, was this a constitutional search and seizure? The defense is going to argue, no, it was not. So let's say in this situation, when I'm preparing for 1538.5 motions, I like to look at case law. So let's craft a quick terms and connector search here. So I'm going to lead with motion to suppress. And I'm going to say I want motion to suppress to appear within the same paragraph as unlawful stop. So this proximity connector tells Lexis that we need these terms to appear within the same paragraph as these terms. Proximity connectors are a really helpful tool to use in your research. And terms and connectors in general are definitely something that you should become comfortable with if you're going to work in criminal law. So one other thing that I would do here is I can imagine a situation where a court is saying maybe unlawful traffic stop, unlawful pedestrian stop. So I want to expand this second portion here to add a second proximity connector. And now I'm asking Lexis to find unlawful within the same sentence as stop. You can also imagine a situation where the judge is saying the stop was unlawful. So this covers that for us as well. So this is just a way to expand your search a little bit more. So now I'm going to hit the search button. Okay. So we have a ton of cases. So this is where our filters come into play. I would say that that is one of the most challenging aspects of researching in criminal law is that there is just an avalanche of cases. So let's, of course, narrow by jurisdiction. So we're going to apply the California filter. And another filter that I really like to use in these situations is the publication status, because I absolutely want to focus on published cases at this point in my research. So now we've narrowed down to 65 cases. So the next thing I would do is I would actually move over to Ravel View. So I'm going to come up here to the upper right-hand corner, and I'm going to move to the far right and click on the Ravel View icon. And Ravel View is going to show us, it's going to plot the top 75 search results from our list onto a graph. And I'm going to give it a second for it to load. But what you'll see is that there's going to be circles for each of the cases. And the bigger the circle, the more influential, the more times it's been cited. Let's see if this will load for us. There we go. So all of these circles represent different cases in our case results list. The bigger the circle, the more seminal the case is, the more times it's been cited. So I would want to probably make sure I'm familiar with all of the big circles. So People v. Miranda, definitely familiar with that. People v. Grant, also very familiar with that. Anyway, I would go through and I would make sure that I'm familiar with all of the bigger circles. And maybe I'll move over here and make sure I'm familiar with these. And actually this People v. Rodriguez one I'm not too familiar with. So I'm going to click on that one. And let's just look at the quick synopsis here. In a drug case, defendant was entitled to an evidentiary hearing on his claim. Okay, blah, blah, blah. Suppression by falsely claiming they stopped the car because of a burnt out brake light. Traffic stop was unlawful. Motion to suppress. This looks like it could be a helpful case for me. So I'm going to open it up. And here we have our case. And the first thing I would look at is I would just click down to the case summary and just have a quick look at this brief summary. And then the next thing I would do is go down to the head notes. Head notes are so helpful as you're performing research, because if you find a good head note, you can use that as a jumping off point to find other cases that are talking about that same issue. So let's scroll through some of these head notes here and try to find a helpful head note. So this one looks good. Warrantless searches, investigative stops. So I'd probably look through this, skim this. It does look like it is going to be helpful for me. So this Shepardized narrow by head note feature, when I click on this, Lexis is going to surface 27 citing decisions that are citing to the same language as head note number 6, and also to the People v. Rodriguez case. So presumably, if head note number 6 is helpful for us, some of these cases could also be helpful for us to review to support our research. So this is a great way for you to find other cases that are going to be helping you understand the issue that you're researching. And all it takes is to find one good case to help you start off your research. So let's go back to the Lexis Plus homepage. So we talked a little bit about the world of criminal law, what it's like to practice there. I showed you where to find some practice area resources by coming to the Explore Content pod, clicking on practice area, and then criminal law and procedure. And then we also talked about 2 different assignments that are very common for criminal law practitioners to encounter. The first one was preparing for a preliminary hearing, and the second one was preparing for a motion to suppress. So the last couple of things I just wanted to say is that in my experience in working in this area, if you're looking at doing an internship, for example, in the public defender's office or the prosecutor's office, I would say that you should really focus on becoming a strong researcher, because the better researcher you are, the cooler assignments and cases you typically get to work on as an intern. That was at least my experience. Another tip that I would share is to watch as many trials and preliminary hearings as you can. It's really valuable to see how other people, different people, present their arguments, cross-examine, all that kind of stuff. So I highly encourage you to watch as many people as you can. And that's all I had for you guys today. I really appreciate your time. And I believe we're going to move on now to the Q&A portion.
Yeah, thank you so much, Adriana. This has been so helpful. I do have some Q&A portions from the registration report, so we're going to start with those.
Okay,
But if the students have any other questions, I encourage you to put them in the chat now. I know I have one Q&A, so go ahead and put those in the Q&A if you have any other questions. And we are going to go ahead and get started with the registration questions. So I am going to put them in the chat just so that everyone can read them. And Adriana, I'll just let you kind of go at them as you see fit.
sure. So when you know your client is guilty of a heinous crime, what are some strategies to help yourself remember your duty to your client? That is a fantastic question. I would say that, you know, your goal, if you're talking, obviously you're talking about a defense attorney's position here. So your role as a defense attorney is to uphold the accused person's constitutional rights. They are entitled to a defense. So, you know, one way that some of my colleagues, you know, did it and that I did it is just remember, like, what I'm working towards here is upholding this person's constitutional rights. Everybody's entitled to a defense. And oftentimes, maybe even most of the time, it's not necessarily about getting your client off, but sometimes it's about mitigating, you know, maybe they're not necessarily guilty of all of the crimes that were charged. Maybe the prosecutor overcharged. So maybe you're just trying to get some of the charges dismissed. But it's just remembering that you are that person's advocate. Doesn't matter what they did, they are entitled to have their advocate be in their corner. Many of, you know, in my experience, many of the people that I worked with, you know, had mental health issues that, you know, may have contributed to the crime, or, you know, perhaps some really terrible things happened to them when they were younger. So also, you know, remembering that they are a person that has had, you know, a lot of different experiences is something that really helped me. And again, you're not necessarily always trying to get the person off. You're just trying to help them get the most just result. Sometimes that means mental health services, or, you know, fighting for mental health services, or fighting for drug court, and helping them get, you know, help for an addiction, that kind of stuff. So I don't know if that answered the question, but I sure hope so. Next question. Has corporations, representatives, officers being prosecuted under criminal law increased corporate accountability? That is a very good question, and that's not really something I can answer. I think that would require some research to see, you know, look at numbers and percentages and things like that. But that is certainly a really good question. How do you advise clients on criminal statutes that are not being enforced without telling them to break the law? This is a very good question too. So oftentimes, you know, you are in a situation where your client is asking you for advice, and you do have to tread carefully because you are bound by, you know, ethical duties, you know, not to advise them to break the law. But, you know, sometimes you have to speak in hypotheticals. And I found myself doing that a lot when I was a criminal law attorney. You know, if there's a situation where this happens, you know, if a person were to do this, and you maybe talk about things in that way, so that they can understand the full picture and make their own decision. I always preface those conversations with, I cannot advise you to break the law. And I would advise them of the consequences if they broke that law. You know, this is a misdemeanor, this is a felony, whatever, things like that. But that's how I used to approach it, just speak in hypotheticals. Plea bargaining, thoughts on plea bargaining, frequency of the same, what does work-life balance look like for you? So less than 5% of criminal cases go to trial. I don't know the exact statistic, but it is definitely less than 5%. So plea bargaining is usually how cases resolve, the vast majority of criminal cases. And my thoughts on them, well, I mean, it's necessary. It would be impossible for the courts to try every single case. There are so many criminal cases that are, you know, pending in the courts across the nation, and it would be impossible. The courts would come to a halt if every single person went to trial. So it is necessary for people to, you know, enter into plea bargains. And sometimes people don't want to take a risk, and they're making the choice to accept a deal and accept a punishment that they can live with, because they'd rather the known punishment rather than the unknown punishment and, the anxiety of going to trial. Work-life balance, that's a tough one, because as a defense attorney, I did, sometimes find it hard because I would, read these cases, these police reports and speak to these clients that were accused of some really heinous crimes. And sometimes it is difficult to, leave that at the door, so to speak, when I was leaving the courthouse each day. But I found a lot of help with working out and a meditation practice and leaving my work at work. So not bringing it home. I did at times bring it home, but in general, my rule was to leave my work at work. How can an intern or new employee work solely with kids? That's a good question. I think that's going to be very jurisdiction specific. I know, for example, in Los Angeles, the way that they train new attorneys is that you have to start out by doing preliminary hearings, and you have to do a certain number before you move on to misdemeanors. And then some people from there move on to felonies, and some people move on to juvie. I don't know how it works in other counties, but at least in Los Angeles County, you did have to go through misdemeanor rotations and some felony assignments before you could work with juvie cases. So that's going to be just jurisdiction specific. How do you implement traditional research strategies into Lexis for firms, offices that still use casebooks? Oh, wow. I don't know of any place that only uses books, but I suppose what you could do if that's a situation that you believe that you're going to encounter is at your law school, you can, practice looking stuff up in the books, in the physical books. I know when I was in law school, that was something that we had to do as part of our legal research and writing class, is become familiar with using the book. So I would just encourage you to visit your law library and get comfortable that way. Okay, so now I'm opening up the Q&A section.
I think we have a few questions in Q&A. One that I think would be great because you can just show it on Lexis is there a way to access briefs, arguments that other attorneys have filed in criminal cases? This person says in California, but I think just showing generally where that information would be is great.
Sure. Yes. So you can access it from the practice area page and come down to criminal law and procedure. By the way, that's a great idea to look at other briefs and arguments that other attorneys have made or filed. So if you scroll down to case-related materials, just above the jury instructions that I showed you earlier, you'll find all criminal law briefs, pleadings, and motions, and you can search that way. Alternatively, you can come to the Explore Content pod and come to Content, and then come to Briefs, Pleadings, and Motions and search it from here as well. And here you can start by filtering to the jurisdiction that you're interested in as well. Okay, do many prosecutors' offices or public defenders' offices use Lexis, or is it mostly private defense firms? I've seen most government offices use Westlaw. That really depends on I guess what the county that particular office is located in has agreed to. I know that in Los Angeles County, when I worked there, we did have both Lexis and Westlaw, but that's just going to vary from county to county. In your field, what has been the response to generative AI? So I assume this is a question specifically about criminal law. It's been a couple of years since I've worked in criminal law, so I can't really answer that. I don't know how criminal law practitioners are viewing the use of generative AI. Though I certainly think that Lexis plus AI could be a really good place to start your research, or maybe start crafting an argument. But that's also going to depend on, the individual county that you're working in, the particular judge you're in front of, what their policies are surrounding the use of generative AI.
All right. Thank you so much, Adriana. I don't know if I see any other questions, so I'll just hang on for a minute or two in case any other questions pop up. But otherwise, thank you so much to everyone who's joined us. Thank you again, Adriana. Like I said, it has been recorded. So your Lexus rep at your individual school should be sending that around. But if you don't see it, feel free to email me and reach out, and I could always send it to you as well. But otherwise, thank you again, everyone, and thank you, Adriana.